Good afternoon, everyone. It's my pleasure to introduce my partner and colleague and the speaker for this afternoon, John Shikoda. John is a member of the firm of Ehrenberg Golgan. He's on the firm's executive management committee, and he currently serves as president of the Chicago Bar Association. John has more than 35 years of experience as a trial lawyer, focusing on complex civil litigation and arbitration, and specifically relating to business disputes. In addition, John serves as arbitrator and mediator and is on the commercial panel of the American Arbitration Association's roster of arbitrators. He is our firm's co-founder and co-chair of the Business Divorce Practice Group. In 2018, he, along with our partner in the corporate transactional group, Jerry Holiski, co-founded the Chicago Bar Association's Business Divorce and Complex Ownership Dispute Committee. And John has co-chaired that committee for the past 6 years. John is a prolific author and publisher. He's written and presented on a variety of topics. The list probably covers 4 or 5 pages, but I'll just note that he co-authored 4 chapters of the IICLE handbook, Disputes Involving Closely Held Companies. Was published in 2020 and updated in 2023. Without further ado, John, it's all yours.
Thank you, Nate, for that wonderful introduction. And thank you. It's an honor to be your partner for many, many years and to have the joy and the gift to work with you at the firm. Of course, Nate is one of our co-chairs of our litigation group. He's been a 50-year plus member, I think, of the Decalogue Society and very active in the bar, and one of the mainstays at our Ehrenberg Golgan law firm. Thank you so much for having me again at the suggestion of Nate to present to one of my favorite bar associations, the Decalogue Society, of which I have many, many friends, and I have a close affinity toward your organization. As one of my mentors and friends, the late Herb Franks, he's such a good friend of mine, was a longstanding member of the Decalogue Society, as well as a number of numerous other people. The Decalogue is one of the most respected and venerable bar associations of all the bar associations in Chicago. And it's a really honor to be here with you today. This is a topic that I really enjoy. I can tell you that my business divorce affinity for this area began when I found myself in a business divorce many, many, many decades ago. I got involved with some family members in a business, and it didn't go very well. So I think I have a very unique perspective of seeing business divorce, not only from the lawyer side and from the arbitrator side, but I also, I've seen it from the client side. So that gives me sort of a troika of perspectives on business divorce. And what is it? I think to start off, we need to talk a little bit about what is a business divorce. This acronym is thrown around a little bit. And Nate and I and our partner, Jerry Holiski, as Nate mentioned, we sort of termed it business divorce, but it's really when you have owners that are in conflict, whether it be a partnership, whether it be a corporation, whether it be a limited liability company, whether it be some other type of entity. It's when owners are in conflict. And what does that exactly mean? Well, it can mean a lot of different things. Sometimes ownership are two owners, 50-50 partners, 50-50 owners. Sometimes there's a 60-40 or a 70-30, and you have a minority owner that is somewhat at the behest of the majority owner. But with that minority ownership, there comes rights under our Illinois Business Corporation Act and under our Illinois LLC Act, as well as under Delaware law and many other states. So our firm and many other firms, we get into these disputes when there is consternation and when there is conflict among owners. And so why does valuation come about? Valuation comes about because at the end of the day, in a business divorce, there's only really 3 or so items that are going to result from this. Either they're going to stay married to each other in business, either one is going to buy out the other if it's a 50-50, or if it's more partners, some of the partners are going to buy out one or more of the other partners, or it's going to be sold to a third party, the entire, either part of it or all of it. So those are the choices. And when that acquisition process happens, what are we going to buy someone out for? Okay. And just lay person's terms vernacular. We need to understand what the value is. What is this worth? Now we're going to talk about over the next hour. We're sort of just going to gloss over things because to really get super granular in this area would take much more than an hour. But I'd like to just touch upon the high points. So if these issues come up in your practice, you'll have a sensitivity to understand a little bit about it. And by the way, if anybody ever needs to ask a question or has a question, you can feel free to reach out to me or Nate or anyone at our Ehrenberg Golgan law firm that's part of our business divorce group. And we're always happy to answer questions because we do get questions all the time in this area. So the valuation process is an important component of how much is your interest worth, okay? And so in these cases, what we do in order to determine that is that we retain business valuation experts. What does that look like? We're going to talk about that today. But one of the very first issues is, what is a business valuation? Well, business valuation is an analysis of the value of someone's interest in the business. And, you know, there's some people like to say in certain sectors, it's a multiple of EBITDA, okay, or something of that nature, but there's much more involved in it. And I will tell you that Nate and I and our firm, we've dealt with many, many business valuations experts over the years. They're all different. They all bring something to the table. Some are better than others in certain circumstances and from certain perspectives. There are some that are very good in terms of technicians that maybe aren't as good as testifying witnesses. There are others that are really great testifying witnesses that maybe not as great technically. But it really depends, and this is really what I think a great lawyer brings to the table, is trying to put together the right valuation expert for the right case. And it's something that when you've had many cases like we have, we sort of know what valuation expert will fit in what particular case. So I'm going to just scroll through a little bit and talk about why is it business valuation critical to any resolution. I think we've talked about that. Why it's critical is because we need to know what the business is worth, what the value is. And obviously, this area is usually the battle of valuation experts if there's a dispute as to value. And by the way, many times there are disputes. You may have somebody at 5 million, you may have the other side at 10 million, and so then and we're going to talk about this a little bit. It's the lawyer's job to test the expert's opinion. And many times that is based upon their assumptions of certain facts that may or may not be accurate. And so we'll talk about that as we get going. By the way, if you have any questions, if you can please put them in either the chat or the Q&A, and then we'll sort of, Nate and I will be checking it, and we'll sort of either answer them upon them coming or at the end. Okay, so please put your questions. That's very important. What does a business valuation mean? I think we talked about that. Business valuation is what is the value of the interest of a particular owner in the business. Why is it important? What are the keys to identifying and finding the right business appraiser? Well, for me, I like to find a business appraiser that fits with the case. Certainly these business appraisers, the ones that we deal with, are very seasoned, are very experienced, have very much experience in testifying, both at deposition and at trial. They've been seasoned. And I like to fit a valuation appraiser and expert with the case. If we're dealing with $1 million case or a $5 million case versus a $20 or $30 million case, that may determine what particular expert I may want to choose, but not always. Obviously, experts are different in terms of their costs, just like lawyers are, but you want to really find an expert. And in particular, this has gotten so, I like to use the word granular, that you could find certain valuation experts that are experts within a subcategory. For instance, if you're dealing with a manufacturer, a certain type of manufacturer, there are actually appraisers out there that are experienced in this particular area. There are appraisers that are experienced in real estate, commercial real estate, certain type of commercial real estate. Maybe if it's industrial warehouses, maybe it's single family homes, maybe it's rentals and large rental properties. So you can really drill down. It's sort of fascinating. I had a technology company years ago where I was trying to find an appraiser that had experience with technology, with intellectual property, because that was the primary asset of the business. Well, lo and behold, I start digging into the expert databases and talking with a few friends, and I found a few appraisers that deal with this particular type of technology. It was amazing. And so I was able to then select one that I thought was a good fit with the case. But really, finding and identifying the right business appraiser is so important to your case, because your case in terms of the buyout, okay, or the sale to a third party is going to really rest upon what that particular expert opines in terms of the valuation and the value of the business. So at first blush, you may not realize that it can get that specific, but it really can. And so I like I said before, I'm happy to always help people find experts, and I sort of like that part of it. It's sort of interesting to me. So if anyone has an issue with regards to that, please let me know. One of the issues that I want to talk about that I don't think lawyers always focus on and I may be in the minority, I don't know, but I like to get business valuation experts involved early in the case. I like to get them involved at the pleading stage, at the preparation of the pleading stage. I have found that good valuation experts have really assisted me in my theory of the case, especially if there's fraud or there's misappropriation that has been involved or at least alleged. And they can really focus you on some of the issues that may be brought up in a business divorce case. For instance, many times, um, some of these appraisers are also forensic accountants or have forensic backgrounds. And so, upon reviewing the financial statements and the financial information, they may be able to identify where there has been some misappropriation or allegedly some fraud or stealing, okay, in the vernacular. And that allows you to um, begin in the pleading stage with your claims for breach of fiduciary duty or conversion or whatnot in a business divorce case. So I'm somebody that gets an expert involved very early in my cases. I think it's important for them. It's important for the client, I believe, for the expert to get involved early. But I also believe it's important for them to get involved early because they learn the facts of the case. They learn about the business. They learn about the dynamic of the business, the dynamic between the ownership, okay, whether it be family or non-family. I think it's important to give them a flavor of what's involved here, what is the perspectives, and what is the context. I think that's an important role. Let's talk about the different methods and techniques of valuing a business. And this is, maybe more art than science, but certainly very, very important. One of the approaches is the income approach. The income approach is value based on present value of the future economic benefits. So that's where they review the financial information. They come up with a value, but it's the present value of future economic stream. Okay. Now, one of the secret sauces that we're going to talk about, I guess I can address it now, but one of the secret sauces in valuation is whether or not the numbers as presented are fair and reasonable. Let me give you an example. There are some businesses that, quite frankly, overpay their owners. So when valuing the business, are you going to back out the ownership compensation to a more reasonable value? There are also fringe benefits that are taken by the owners that for purposes of valuation, should they be included? Should some of them be included? That's where a great expert appraiser is going to help you. Also, years ago, I had an expert appraiser help me develop the fact that one of the owners, this was a 50-50 case, one of the owners was stealing from the business. I mean, stealing a lot. So what we did in terms of valuation is we backed out what we estimated to be the conversion amounts. And that was the way that we got to the valuation on an income approach. So if you have a great appraiser and a great expert that also, and by the way, sometimes you need two experts. You need a valuation expert and you need a forensic accountant expert to help you develop whether or not there has been any misappropriation. The next approach is the market approach. And this is multiples from comparable arm's length transactions, either public or private. So this is scouring the marketplace to determine what our businesses are like kind businesses. What have they been sold for, and how have they been valued in a supply and demand and an arm's length transaction? It's a very interesting way. It's the way they develop those are very interesting, and they're able to really drill down on the fact of, this business in this location based upon this revenue and this expense side is valued at a certain amount. And then another approach is the asset approach. And that is the market value of assets less liabilities. So it's really assets minus liabilities. What does it equal? And depending on the type of business you have, will depend upon the type of methodology is best for your appraiser to use for your particular business. This is another very interesting area where, a lot of times I'll have experts value it with all three. Also, discounted cash flow is another methodology. But I'll have them, let me see it on a board. Let me see all three or four of them. And then we can determine what way we want to go. But obviously, it's the expert's opinion. It's not the lawyer's opinion. It's their opinion because they have to testify to it, and they have to swear that this is their honest opinion as to the value.
John, if I could step in for a moment.
Yes.
Mike Burke raised an interesting question in the chat box. He asked how a business valuation differs from a real estate appraisal for, say, commercial property. And I think from the three approaches that you just covered, the closest analogy to a real estate appraisal is the market approach, because you're looking for comparables. That's how a real estate appraiser would typically value property. You indicated there's obviously three approaches to valuing a business, but one of those, the market approach, is, I would argue, pretty similar to a real estate appraisal.
Yeah, thank you, Mike, for that question. And yes, Nate, I absolutely agree with you. What's interesting is and I had this case years ago where we had a real estate firm, a commercial real estate firm, in a business divorce. So we were looking at the business and, of course, the profits and the analysis of the business, but then trying to determine, and I can't remember what approach we used there, but I do agree with you. I think the market approach is the closest to a real estate appraisal firm, because obviously they're looking for comparables in the same area, and that would be very similar. One of the very interesting issues on the market approach is, and experts will get into a big tizzy over this, is, you have a business in Chicago versus in, small town Kentucky, right? And so what are the different dynamics in terms of workforce, labor costs, insurance costs, and all that? So it's pretty, I've sat down with appraisers over the years. It's a really interesting area once you get pretty granular into it, and it's fascinating. It's dealing with numbers, but it's also dealing with interpretation. So for me, it's been fascinating.
Let me just, if I could, John, just add one more point. One of the challenges of a business valuation as opposed to a real estate valuation is the database. All real estate transactions are publicly disclosed either by recordings or filings. And so real estate appraisers typically have the same kind of database available across the city or across a country. The art in a real estate appraisal is which ones are considered comparables and what are the adjustments. The challenge in appraising a business very often is trying to get the data. And there's two kinds of data, which, John, you you talked about a few moments ago, which is publicly traded companies who are bought and sold, and private companies. And private companies transactions are typically not available to the public, and so many of these expert appraisers and valuation experts have access to databases in the private sector that we would ordinarily not have access to.
Very good point, Nate. That's exactly right. I think someone may have had another question. Michael Burke may have suggested something regarding, is it something to put into a partnership agreement? I wasn't able to read the whole question.
Yeah, I think he's, in a business dispute, I think his question is, can you deal with or anticipate a business dispute, a shareholder dispute, by having some provision in the operating agreement or the partnership agreement relating to what happens if there's a falling out?
Great question. And usually at Ehrenberg, our great transactional lawyers will almost always require that there be a buy-sell agreement, either if it's a corporation or partnership being a separate agreement, or within the LLC operating agreement, that there is a buy-sell provisions which lay out how the business is going to be valued, in what manner, and it can get quite specific. There could be drag and tag rights as well, that maybe we can do a separate seminar on that. But so I think, and Michael, you raise a very good point. I think it's best for owners when they go into the business, of course, if they're represented by, I think, really quality lawyers, the lawyers will tell them at the beginning to agree upon a methodology in a buy-sell agreement or buy-sell provisions in an operating agreement as to what happens. What happens if, it's just time to get divorced? How do we proceed? And in what manner? And a lot of times, if there's minority interests involved in the business, in the operating agreement or in the buy-sell agreement, there will be provisions for purposes of how to determine fair value. Will there be discounts for lack of marketability, okay, and otherwise? And how to determine fair value? What is the way to determine fair value? Of course, in Illinois, fair value does not encompass any discounts, okay? Either under the Delaware rule or under the Illinois rule, correct, Nate?
That is correct. In the ordinary case, the BCA does not permit any discounts.
Right. And so that's something that many lay people, okay, our clients that aren't lawyers, they don't understand that. They believe that if you're a minority and you have a lack of marketability and alienability, therefore you cannot sell your interest to an outside third party, that you should be subject to these discounts. And what is really hard for us as lawyers is we have to tell them, well, under Illinois law and Delaware, there is no discounts that are used for purposes of determining fair value. But here's the secrets, and some of the secret sauce, I think, in determining the numbers. I alluded to the fact that many times in these cases, there are salaries are inflated. There can be misappropriation. There can be usurpation of corporate opportunity or diversion of opportunity. There can be self-dealing. There can be breaches of loyalty, breaches of fiduciary duty. And how does the expert essentially back that out for purposes of valuation. And to have a very experienced and quality appraiser, they will identify those issues and they'll be able to, I like to call it, recalibrate the income streams, okay, for purposes of profitability and therefore for determining fair value. Over the years, Nate and I and all of us have had many cases where there have been, malfeasance, stealing, usurpation of corporate opportunity, self-dealing, um, loans that have been taken out that really should be deemed to be income, and all this kind of maneuvering, as we all know, that business owners will sometimes do. So you need to really have an expert that understands this, and for them to be able to recalibrate the financial picture of the business. Do we have another question, Nate? You're on mute, Nate.
Okay, I think I'm back on.
You're back.
There's a question relating to the income approach for valuation. Are there issues that come up in determining the proper discount rate to be used for present valuing the income?
All the time. All the time. The discount rate for present value, of course, is always looked at is over the period of time that you're looking at, what can your return be? What is the fair return, right? And so they look at interest rates, they look at, the marketplace, but there's always a fight, whether it should be 3%, 5%, 7%, 1%. And that's a big issue in the income approach, because a true and accurate income approach is giving you the present value of a number with respect to what kind of return can you expect over a given period. And obviously, it all depends upon interpretation of the marketplace, what are current interest rates, where do we think they're going? So yes, the answer, quite frankly, is that is always a battle, but usually it gets worked out. Both sides have their interests there, right? One wants it high, one wants it low. But I think that's where your good lawyering and good experts can really help you. So fair value is certainly the end of the line for purposes of the objective for our appraiser. So this is an area where I've spoken a lot about, and it's how to use your valuation expert for the best results. I believe that valuation experts, as well as any expert, has to be able to take very technical information and boil it down so it's very understandable to the trier of fact, whether it be a judge or a jury. And there are some of us and experts that can do that, and there are others that have a challenge with respect to that. But if you can't break it down, I have a partner that always says that experts should be able to testify as if they were speaking to a 7th grade classroom. And, there's a lot of truth to that. There's a lot of truth that, many judges, as we know, and less so in arbitration, because if you get an arbitrator in this area, they're going to pretty much be experienced. But a lot of times the bench, and certainly jurors, they don't have this technical expertise. Many of them do not have financial expertise or experience. So I really work very hard with experts to get them to really boil it down and for it to be very simply expressed so it could be understood. And I almost have them talk to me about, explain it to me, because if I can figure it out, and I have experience in this area, if I think you need to dummy it down even more, then you need to dummy it down. But so I really spend a lot of time with experts in terms of reading, obviously reading their reports, giving them comments, but not changing their opinions. A lot of times, the comments that Nate and I and our team at the firm, we give them feedback when we believe that they have relied upon a fact that may not be accurate or an assumption that may not be right. And I like to test the assumptions with experts. I like to, battle with them. And in terms of preparing them for testimony, I think we have that in another page coming up front. But I think that you have to be able to use this expert to express this opinion in a very basic way, a basic way that has technical soundness to it, has methodology soundness to it, and is an opinion that can be relied upon. And so dealing with the experts is very important in that regard. Nate, you have any thoughts on that? Because that's a very important aspect.
Yeah, I think, and this is true in almost every case where you have experts, but certainly involving valuation experts, it really has to be presented in a way that is both compelling and understandable. And it's a challenge, and it's something that over time, working with jurors or with different judges, you begin to appreciate certain kinds of approaches. And as John mentioned, there are experts who are, who may be excellent on the technical aspects, but may not be able to present it in a way that's going to be understandable and compelling.
So our next slide is what a prudent valuation expert can provide to enhance your success. We talked about this a little bit. I think really what I look for and we look for in valuation experts is what is the added value that they can provide to us? Whether it be either a forensic analysis, whether it be the recalibration of the financial snapshot of the business, whether it be their experience in a particular business sector or area, whether it be someone who is very technically gifted, but also gifted in terms of being able to, as Nate indicated, breaking it down where it's understandable as well as being persuasive and compelling. I think, valuation experts, like lawyers, they come in different shapes and sizes. And I think the key to it is you have to be able to fit the right valuation expert with the right case and the right subject matter. And for that matter, if it's before a judge, before the right judge, and obviously if it's a jury, before the jury. I think there needs to be a lot of analysis getting into identifying experts. And typically what we will do with the client usually is interview 2 or 3 of them to, get a comfort level as to their willingness to deal with this and, what their opinion may be. I mean, usually we first want to identify consulting experts and then to testifying experts. And we've had consulting experts that have told us, hey, this isn't going to be where your client thinks it should be. So there's always the client expectation in these cases, like in all cases, that you have to deal with. And, you could shotgun and wind up speaking to 10 experts to finally get somebody to tell you what you want to hear. But at the end of the day, that might not carry the day, and your client's going to be much more upset if you select someone who just told you what you wanted to hear, and then at the end of the day, you lose at trial, or you lose at mediation, or you lose at arbitration. So, I think it's always best to pick somebody that's obviously very responsible, reliable, and honest to give you, their real number. Let's talk about the valuation report and its key features. I'll never forget when I was a young lawyer, and this was before email, and it might have even been before fax, or fax was in its early days, but it was many years ago, almost 40 years ago. And I didn't realize that drafts were discoverable, right? Right, Nate? Draft reports are discoverable. So I took the draft report and I sent a bunch of the draft reports to the expert that had all kind of writing on it from our firm. Just questions. We weren't trying to influence the opinion. And I remember the senior partner coming in saying, we can't do that. That's discoverable. And so I learned a real lesson as a young lawyer, that you have to be extremely careful of drafts when you're dealing with expert witnesses, because that, of course, is discoverable. And I just tell that story because it's a lesson, and an important lesson, that we at our firm really police quite heavily. And you can't police it enough to understand where the flow of information goes. And in today's world with email, it can be also even a more dangerous situation. So,
John, there's a question Judge Jordan asks on this topic. Is there an obligation in discovery to disclose other opinions that might be adverse to your client?
Thank you, Judge Jordan. Great question. I think that if it's a consulting expert, I would take the position, and I haven't looked at this issue in quite a while, I would take the position that you do not have to disclose it, especially if it's not in writing, because usually an expert will give you a negative opinion orally. I may be wrong on that. Certainly if it's testifying, I think you do. Nate, what do you think?
Yeah, I would just say briefly, and this is a much broader topic, but I would say briefly as follows. If it's a consulting expert that has only communicated with you as an attorney, and that information has not been discussed or revealed to the client, then that is covered under work product, and under the federal rules certainly, and I think under state law as well, there is absolutely no requirement to disclose. The problem comes in when you have a consulting expert who in the course of their work has had conversations with your client or disclosed information in writing or verbally to the client, and then the client is required either in a deposition or by interrogatories, if they're asked the question, have you ever had or seen an opinion, an appraisal that differs from the one that your testifying expert has provided, he would have to answer that question, because the communication between a consulting expert and the client is not attorney-client privilege, obviously, and it's not work product.
I think that's the analysis, Nate. And in my discussion that I just had, I should have been more specific. When I say orally, I meant to say an oral discussion with the consulting expert, not in the presence of the client, because I think you're absolutely right. We hired the consulting expert. It's work product. But this is I spoke at an ABA uh, business law section CLE a couple of years ago in Washington, D.C. about this very topic. And many of the lawyers that were on the panel and in the audience talked about how their firms have implemented very strict measures in terms of how to deal with expert discussions. And there's in some cases, there's a written protocol. But this is a very dangerous area that if in fact this becomes discoverable, can be very detrimental to your case. And so you have to take, partners in charge of associates and younger lawyers. You have to really take charge of this situation to ensure that this does not become something that can be discoverable. And Nate's example is the perfect example of how it comes about at deposition or in interrogatories, or emails, of course, are always deadly when it's sent to both the client and the consulting expert. So you have to be extremely careful. But in terms of the valuation report, you want to go over, I think, in very great detail, the assumptions and the facts that are relied upon for those assumptions in terms of coming to the opinion. Not that you're changing the opinion, but you want to make sure that the expert's opinion is well-grounded in fact and law and is accurate. And I think those are one of the key points of the valuation report. Of course, you'll have the curriculum vitae of the expert. You'll have the information that the expert was provided. You'll have the expert's compensation. But in terms of the opinion, you want to make certain that it's well grounded in fact and in law and upon the right assumptions. Because we all know at deposition, what good lawyers are going to do is going to attack those assumptions and those facts. So we have to make sure of that. This is always a fun area, how to prepare your valuation expert to testify. Well, I can tell you that for really any witness, but especially for expert witnesses, we conduct mock depositions. So we take their deposition as if we're the other side, and we drill down on all of their opinions, all of their assumptions, the facts that they base their opinions on and their assumptions on. And let me tell you why I think it's good prep for the expert, but it's even better for you. I've always said, and Nate says this, you have to know your opponent's case as well as they do in order to prepare for your case. And when you're taking a mock deposition of your valuation expert, or for that matter, any expert or any witness, you have to know the other side's case. And that's how you can best present your case or anticipate or defend theories and claims by the other side. So we take an extreme amount and an exhaustive amount of time going through testimony, prepping the witnesses, going over their testimony, and then conducting mock deposition testimony of them so they can really get prepared to understand what's going to happen, the type of questions that they're going to receive, having them not be argumentative, but listening to the question carefully. So, and then of course you have to do the same thing for the direct examination of the expert at trial or at arbitration. And then we prep them again for the cross. But really the deposition testimony is a very important piece. Nate, anything to add on that?
No, that's a good approach.
The other thing is, how do we how do we get them to connect with the trier of facts? Well, I think any witness, but especially expert witnesses, have to be likable, they have to be relatable, and they have to be authentic and trustworthy. If they are authentic and trustworthy, and they look and sound like they know what they're talking about, and they don't gild the lily, or they don't go over their skis in terms of their assumptions or their opinions, and they seem reasonable, I think more than likely triers of fact, juries and judges will relate to them. If they start going over their skis and testifying, way outside, the ballywick, way outside of what is reasonable, I think they're not authentic. And I think trier of facts don't really connect with them as best as they can. So we really work at that. We really work to get them to be relatable, to be likable, and to be authentic. I mean, we all know witnesses that are not authentic. And for that matter, anybody that's not authentic, you're not going to connect. And if you don't connect, you're not going to resonate. And if you don't resonate, they're not going to listen to you. And I guarantee you one thing, if they don't like you, they're definitely not going to listen to you. So I think likability to me and relatability is a really important feature that you have to work with experts, and for that matter, any witness. We've got about, I don't know, 6 minutes or so. Are there any questions that we have not dealt with?
Actually, John, I just wanted to, I don't want to intervene on or interrupt anyone's questions, but one additional item that came to mind and basically arises out of Judge Jordan's comment is this. When we prepare our clients for depositions or for trial, we're comfortable in knowing that whatever we say, whatever documents we provided to them, our conversations, our discussions are not discoverable, and they're not going to be covered at trial. But anything you show, anything you discuss, any documents you provide your expert are fair game. They are discoverable, and so one just has to keep that in mind as you're working with your expert, both in the early parts of a case and certainly in the course of the litigation.
Great point, Nate. There were some years ago, I was involved in deposition and then trial in a case which eventually settled, and it was a confidential settlement. But what we were able to discover is that the lawyers had essentially written part of the expert report. We had gotten drafts and documents that they had provided to them, and they included the drafts. And obviously we made a bunch of hay out of that, and eventually the case resolved itself. But one of the things that lawyers have to be very cognizant about is, even for obviously for deposition testimony, whatever documents are provided to the witnesses at trial, it's fair game. And that's why you have to really have a real tight handle on what you're providing to them, who's involved in the discussions, and to maintain you not getting very surprised at trial. So it's a very dangerous area, and you need to be really mindful of what you're doing. The other thing that I'd like to talk about is, you know, there is, in some instances, lawyers are sometimes very reluctant to get into the fees that have been charged by these experts. That's fair game. Usually we ask an interrogatory regarding that, and I think you're entitled to go into it, what they did, what they charge, and what did they do in terms of preparing. So don't be gun shy about that at all. I think it's really important to test that. They're going to test it on your side, so you better test it on their side. I think somebody had another question, Nate.
Yeah, John, there's a couple questions in the chat box. One on taxes. How do taxes on partners or shareholders basis affect the valuation?
So trying to think this through. So the basis that you have in the business, or the value of the basis in terms of what you sell it for, obviously what is in excess of the basis, less any adjustments to basis, is taxable. I can't really answer as I sit here. I'm trying to think about what is the basis, how does that affect the valuation. I'm not seeing that it does right now.
Yeah,
I don't.
Yeah, my own sense is in the technical approach to valuation, whatever the basis the shareholder has is really of no relevance. It may end up obviously being quite relevant if there's a buyout or if there's a settlement in terms of each shareholder's tax obligations. But from the valuation point of view, from the appraiser's point of view, the basis that a shareholder or a partner or a member of an LLC has in the company is not relevant.
That's
Judge
how I
Jordan
see it too. I see
Judge
that too.
Jordan had a question. What does goodwill or badwill play in the valuation process?
I think goodwill is certainly a component of it. I think badwill is a component of it. I think many times the experts they battle, right, Nate, over this goodwill component. In terms of what's the value of it? What's the real, how do you assess the value of goodwill? In other words, if a business has been a very venerable business, been in business many, many years, over many generations, there's a value to that, right? There's also a value to bad reputation or bad will, right? So I think it's an important component that is subject to interpretation, but it's one of those idiosyncrasies, I think, when it's regarding valuation. But it is Judge, thank you for that. It's a very important component.
Well, I'd like to thank you very much for the presentation. I think that there was a lot of information that was very useful to people. We're going to do an evaluation poll in a moment, so I'm going to ask people to please stay on.